Hello, everybody, and very good evening if you're listening to us in the evening, and warm welcome to another edition of BWF's regular weekend update on immigration law in the UK. So this afternoon, we'll be discussing sole responsibility and how you're able to retain that right even if there's somebody else abroad looking after your child. We've discussed that there are two separate routes to bring your child who is under the age of 18 into the UK. First of all being the entry clearance as a child of a person who has limited leave to remain here in the UK, or a person whose parent is married to somebody who is settled here and so has been granted 2.5 years limited leave to remain or limited leave to enter. And we've also seen the other one, which is paragraph 297, which basically is about somebody whose parent is settled here in the UK and looking to bring their child who is under 18 from outside the UK. Now, sole responsibility is a very big issue when you're applying for a child under this or these routes. We've seen that normally if you've left your home country or home of origin and you've come to the UK and you're now settled, and then the law allows you to be able to bring your child to the UK. However, you need to demonstrate that you're the one that has sole responsibility for the child. And we've seen that sole responsibility as defined in the law, the leading case being TD Yearman, shows that you have to be able to demonstrate that you are the one who is exercising overall control over the child. How do we demonstrate that we've got overall control of the child? So you're in charge of the child's school, you're in charge of making decisions as to which hospital the child goes to. All of the other things that involves the child's upbringing, you're in charge and you're the person that is dictating that. However, being delegated to somebody who is back home and looking after the child. We've seen from the case of Emmanuel, a 1972 immigration administrative review case, that yes, if you're somebody in that situation and you've delegated all of these responsibilities to somebody outside the UK to do for you, then you don't lose that right, because yes indeed, because of the geographical location of the child and yourself, it will require somebody who is in that same location with the child to be able to do those things for the child. However, with your authority and with your basically control from outside the UK. And so you don't lose that right of having a sole responsibility. Usually, you'd be able to show that the other parent is either they abdicated their parental responsibility, is not part of the child's life, doesn't play any role at all. And so this child that we're talking about is probably living with your family. For instance, the child's grandmother or grandfather, or child's auntie or uncle, or anybody at all who is probably not even related to the child. But then you have given this person the authority, the permission to act in your stead and take care of this child. And so you don't lose that right. We have to be very careful if we're making an application, because once you involve the other parent, then the idea is that you don't have sole responsibility for the child. We've seen situations where the other parents have written letters, sworn statutory declarations to say, yes, I give consent and I want to give permission for my other partner who is in the UK to bring the children to the UK to live with them. You have to be careful with that. We've also seen that in situations where the other parent, though is still in Ghana or outside the UK, but then doesn't have the capacity to take care of the children, yes, you can still make the application and raise that with the Home Office, and you'll be able to sail through with that application. It's a very difficult application. I would encourage you not to do it yourself if you don't know what you're doing. Speak to the experts, speak to BWF Solicitors, where 214 to 218 High Road on Seven Sisters, N154NP. Our telephone number is 0208 493 7340. 0208 493 7340. If you need our assistance in applying for your child to come to the UK, by all means, please give us a call or visit us in the office. Bear in mind, if you have limited leave to remain, you can still bring your child. In certain circumstances, you don't need to meet the 18,600 that is set for people under Appendix F and applying as a partner. You only need to meet the maintenance requirement as defined in the case of Uvovo and KA Pakistan. So yes, this is what we've been discussing this afternoon on the platform on the community and the law, hosted by yours truly, Eureku Owusu Frimpong. It's been an absolute pleasure coming your way. Stick and stay with us. Same time next week, we'll be right here with another topical issue for you. Thank you very much and have a very blessed week.